Well, hello, Uncivil Law fans. I hope you're having a great day, and I am in good spirits. So we are here to do our weekly Q&A slash hangout slash whatever, our informal time together. We don't have to have a particular agenda or particular stories. We can just talk about stuff, and we can answer questions that you have and answer some channel comments and all that good stuff. So it's all kinds of fun. So we're going to do that. And we are going to start with the questions that you have put in the Discord. There aren't actually very many of them, to be honest, but that's okay. We will answer them nevertheless. So these are the questions that you have asked over the last 2 weeks or so, because we haven't done one of these Q&As in a little bit, but that's okay. We're here now. Todd asked on April the 14th, are all these instances of police overreacting indicative that we're choosing the wrong people to be police? You can be too smart to be a cop. He's right in so much as there was a court case, somewhat famously, where a person was not hired by the police specifically because their IQ was too high. Seriously, they did too well on an aptitude test and they weren't hired. And the court said, yeah, you can discriminate on that basis because being too smart is not a disability, so you're not in a protected class, so, yeah. So, yeah, you can, apparently, at least in some police departments, be too smart to be a cop. That may not be true of all police departments, but at least one. Continuing with this comment, higher levels of intelligence are correlated highly to higher levels of emotional self-regulation. I'm not sure if that's true or not, but I'll take your word for it. Are the individuals we're selecting as police, these overreacting individuals especially, not intelligent enough to, in the heat of the moment, recognize when a situation has gone from threatening, justifying use of force, to merely risky, where no such justification exists, as is part of a pattern? Well, it depends a little bit how you're asking the question, but I'm not sure that any level of intelligence is necessarily sufficient to necessarily tell the difference between those two things, because situations are very dynamic, and it's also a matter of perspective and vantage point, which is not consistent. So I'm not sure it's necessarily an intelligence issue. It might be an emotional regulation issue, especially in the more blatant cases, but is this part of a pattern? Having that ability not to hire someone who's too smart is basically asking emotionally immature fat children read as adults, guns and badges. Let's give the guns and power to the lowest common intellectual denominator. Sounds like a recipe for what we're seeing as of late. Well, for me, I think it's mostly a problem of insufficient training. And the training that we give police is just not sufficient in any sense. They go through the academy, and then after that, there's some refresher training, but not nearly the amount there should be. And no, not that I'm necessarily an expert in this thing, but if I had to make a number off the top of my head of what sounds like a good number, I'd say 20% of the time. So I don't know if that's realistic or sufficient or over or too much. Maybe it's too much. I don't know. Maybe it should be 10% of the time, which would be, depending on which of those numbers it would either be 1 day a week or 1 day every 2 weeks. That would be the difference between 20% and 10% of the time. So maybe it should be 10% of the time or 20% of the time. So every Friday or every other Friday, instead of being on patrol, you would have some sort of refresher training. So it would be, go grapple and do some grapple training, go do some shooting training, go do some de-escalation training, go do whatever the training is that would be good as a refresher. So, I think it's mainly an issue of not having sufficient and repeated enough training. A lot of police departments will only have annual re-qualification on a firearm, which shows you know how to shoot a firearm in sort of the technical mechanic aspect of it, but not necessarily in terms of judgment. So I don't know if it's not so much an issue with who we're hiring as the training we're giving them. I'm not willing to say that I necessarily would do any better if it were me. Also, I might not be the right temperament person in the first place, but I'm not 100% confident that I would necessarily be able to do better, even though I like to think I'm a reasonably intelligent guy. So I don't know enough to be able to answer the question. So I use my intelligence to recognize my own limitations, which is always a good place to start. It's like I don't know enough to answer the question, but from what I can say is that there just seems to be insufficient training, which also is a very sort of blowback aspect of the defund the police. Not only do we not need to defund police, we need to more fund police, or at least reallocate the funding of the police to also include more training time. So that seems prudent to me. It's always good to have refreshers. Also, I say that as a person who really, really hates continuing legal education. So I don't know. I have to do 12 hours formally every year of continuing legal education. So 12 hours total. And I still hate it. Mostly because it's really, really boring. And I find it to be a complete waste of my time. But so maybe I'm not one to talk at all on this subject. But then again, I do a lot of my own continuing legal education informally because I read a ton of cases, as you guys have noticed, because of this channel, which I don't get credit for. I suppose if I really, really asked nicely and gave all the documentation, like maybe, probably could get CLE training credit if I really wanted to, but I don't really want to have that fight with the CLE office. So I don't, because I can't be bothered. But yeah, that's sort of what I think about all of that. Azeroth asked on April the 15th, which upcoming case do you hope the Supreme Court doesn't cower in on the face of FDR's 2.0 bald-faced threat of packing? I don't know if the packing thing is going to go anywhere. I think that everyone sort of recognizes the downside of it. So I think there's a lot of bluster, and it's an incredibly bad idea for all the reasons that everyone has been able to enumerate. So I'm not sure that us having a 39-member Supreme Court is really the greatest plan. So maybe we shouldn't do that. Yeah. Kate asked on April the 16th, if you had to choose a different area of law to practice in as your day job, what would it be? Probably criminal prosecution. I think it would be interesting. I'd like, or actually, for that matter, how about judge? Either one will be fine. I think I'd be a very good judge. I'd be better as a court of appeals judge than a trial judge, although I don't have the credentials for court of appeals, which is kind of annoying. But I'd be better as a court of appeals judge because I'm more interested in the legal aspects of the law, which might sound like a slightly stupid thing to say, but trial judges are much more fact-focused. They're much more hands-on, on the ground. They are signing warrants. They are supervising prosecutors. They're supervising defense attorneys. They're there on the ground in the heart of it. They get to sometimes ask questions. They get to, be demigods of their courtroom, which is kind of a nice thing. So there's a lot of appeal to being a trial judge, if you like that kind of thing. And I'm not necessarily opposed to that kind of thing, but I'm much more interested in the law. It's like I don't want to deal with them. I don't want to deal with the defense lawyers yapping, and I don't want to deal with the prosecutors yapping, and I don't want to tell them that I'm the demigod and I will now dictate to them reality, as much fun as that sounds like, because I don't want to deal with the hassle in the first place. Why not just come to me as the appellate judge? And I don't have to figure out any facts. It's great. I don't have to figure out any facts. It's great. You just come to me and be like, here are the facts. We bestow them on you. We just give them to you. Aww. And now you get to go figure out what the law is and not figure out all that messy fact stuff about who said what and who should be believed and blah, 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 blah. Someone already did all that for me. It's great. So I would love to be a court of appeals judge. I don't think that the United States Senate is likely to confirm me at this time, given my history as a lawyer. I don't think I have the requisite background for it, which is very disappointing. I might try to run for Texas trial judge sometime, which might be interesting. Because those are elected offices in Texas. So I could run for judge, I suppose. Maybe I should run for court of appeals judge in Texas. That means I have to get money together and friends, be people who do campaigning for me, put up billboards. I don't know, man. But yeah, judge sounds pretty good. In the absence of that, yeah, I want to be a criminal prosecutor. Federal criminal prosecutor sounds pretty good. The DC Department of Justice, the trial level could use some help because of all the many capital rioters. So I'm just saying, it would mean moving back to DC, which is annoying, but I would do it for my country. So if the Department of Justice is looking for a conservative prosecutor to go nail some of these Capitol rioters to the absolute wall, I'm your guy. I will happily do it. No problem. Yeah, so appoint me. I'm available. So those would be my alternatives to my current day job. Matthew said on April the 22nd, in regard to the Chauvin conviction, so I've been thinking about third degree after what you asked about the other day, my thoughts. What about an argument that police work is inherently dangerous to others as it creates crowds, etc., where people can be hurt? Doesn't really work for me. Nice idea. The problem isn't the nature of the way I read the case law, Matt, and the way I read the case law in Minnesota, there is a difference between the number of people that are targeted by an act and the number of people that are threatened by the act. So if you shoot into a crowd, I know the number of people threatened is a plurality. Even if it's a crowd of one. Well, actually, yeah. Because in third degree murder, it doesn't matter. Or second degree murder, it doesn't matter. So if you shoot into a crowd of some number of people, whether it's one or more, then either way, that's second or third degree murder. The difference between second and third degree murder is not how many people are being threatened, the way I read the relevant law. The difference is how many people are being targeted. So the difference is I'm shooting into a crowd. Am I trying to hit someone in particular or not? This goes to my actual intent, what's in my mind. So, what we can prove to a jury is a whole nother set of problems. But as a theoretical exercise, as a purely theoretical exercise, the way I read the law in Minnesota is if I'm specifically targeting a particular person in the crowd, regardless of how many people's in the crowd, it could be 1, it could be 100, it could be 1,000,000, doesn't matter. As long as I'm specifically targeting a particular person or even a specific group of people, if I'm in some sense targeting people, if I have them specifically in mind, that's probably second degree murder. If I don't have anyone particular in mind, if I'm just shooting into the crowd with no one particular in mind, then that's third degree. So I don't think that works to separate second and third degree murder in this hypothetical. So yeah, you could argue that what the police do is inherently creating a risk to a plurality of people, but I still don't think it answers the question of who's being targeted by the act, and so it's not doing anything for me there. Matt continues with the question. As such, they create a dangerous situation which is not allowable due to excessive force. Basically, since the totality of circumstances creates a dangerous situation to others, regardless of if the knee on the neck was dangerous to others, the totality of circumstances were dangerous to others, and such third degree is allowable as the intent is targeted generally in creating the situation. So you want to try to say that it's targeted because they're creating the crowd. I don't think that works because, especially for the police, it might work for someone else, but I don't think it works for the police because even assuming that the police are by their nature creating a crowd by their acts typically are lawful. So you can't really say, well, by their actions, they're creating a crowd and in some sense should be penalized for that because they can't not create a crowd. They don't have the choice not to create the crowd. Their actions will or will not create the crowd and they can't avoid it because they have a legal duty, or at least they have a legal duty to the public at large. So, I don't think that quite works. It's an interesting idea, but it doesn't really do very much for me. But nice idea. So let's see what is next. But I like that you're thinking, Matt. I like that you're thinking. You're asking intelligent questions, which is nice for a change. So we'll give you credit for that. So we won't be too hard on you for today's question. All right, where were we? Okay. Kratos asked on April the 22nd, do you believe race did not play a part in the George Floyd case? It was never argued, it was never alleged, and at least for myself, I was able to draw conclusions with that regard to race. So, I mean, I can't speak to what anyone else did, but yeah. I do ask myself the question, if a big black guy had not handed over a fake note, was this ever proven? Would the police have been called? Don't know. Would Chauvin have kept his knee on his neck for that long? Quite possibly. There have definitely been instances involving non-minorities with similar conduct, so quite possibly. Even if he's told no pulse. Maybe. I know Nate doesn't think so, but I find it hard to believe a white man in this situation wouldn't have the same outcome. There are white men who have had similar outcomes. They've not gotten as much press, but it has happened. But I think even the wrong type of white man, pardon me. I think even the wrong type of white man would have had problems. Someone looking and dressing from what the assumption is of poor background. Compare it to a man in a suit and a Rolex, one might assume is educated and wealthy. I couldn't say. I really couldn't say, but that's more of a class issue than race issue. So, I don't know. I don't know if it makes... I think people's behavior is more... I think people's dress might be indicative of their behavior. I mean, you do make patterns in your mind, so... Probably, but I don't know that you can make a conclusion either way. Crone asked on April the 22nd, since there's talks of Democrats wanting to make D.C. a state, how would that conflict with the 23rd Amendment to the Constitution, which gave D.C. votes in the Electoral College? Would the 23rd have to be repealed before this could happen? From my understanding, since the 23rd specifically addressed this, would the entire amendment become redundant if D.C. is made into a state? Well, Crone, the current bill that is before Congress has attempted to solve this problem by shrinking D.C. in its size to basically encompass the Capitol building, the White House, and I think other parts of what's sometimes called the mall, which connects them. I don't remember the exact dimensions of the district, but there is a map of the proposal. So the way they've tried to solve this problem is by shrinking the scope of the 23rd Amendment in terms of its scope, or in terms of its geographic scope, to be the Hill at all, where no one lives. And the 23rd Amendment does provide that Congress can direct how those electoral votes will be cast. So Congress could choose to give the vote to people, or in the alternative, they could choose to do what states used to do, which is make a decision themselves. So presumably what our new DC would do in this hypothetical universe is the Congress would pass a law that says, whoever gets the most popular vote gets our electoral votes. So that's how they would solve it. Because DC, the new DC would have no people living in it. That's the idea. Okay. So that's how they solved the 23rd Amendment problem. Does it solve the 23rd Amendment problem? Probably. But there's actually another problem that is actually more interesting and I think harder to overcome. And this goes back to real property law for all of our law school friends. So we get to go back into our minds. All the lawyers go back in their mind and they try to remember real property law. All right. So Matt will know this one because he's had this question recently on a bar exam, or at least a essay similar to this. Okay. If you give a piece of land to a person for a purpose, and that purpose ceases to happen, then what happens to the land? And the answer is, in law, typically in common law, the answer is the land reverts, right? So you can give a piece of land, and this is why real property law gets so endlessly confusing, because you can have caveats of caveats of caveats of caveats. You gave someone land. Okay, How did you give it to them? Then we get to ask 3 bajillion questions. Did you give it to them fee simple? Did you give it to them as a life estate? Did you give them as a joint tenancy? Did you give them as tenancy in entirety? Oh, wait. Did you give it only for mineral rights or only for these rights or this rights? Did you give it for a particular purpose? Did you give it for a life that won't necessarily be in existence 21 years after the date of the bequest? Blah, 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 blah. 3 bajillion questions later, everyone loses their mind. But anyways, forgetting all that for a second, we'll go back to the easier one of if you sell/give land to someone for a particular reason, and that particular reason no longer exists, the land reverts. So why is that relevant? Well, because when Maryland gave the land to DC to become DC, because it used to be Maryland at one point. So when Maryland gave the land to DC to be DC, they gave it to DC for the purpose of being DC. Okay? Now, that's perfectly fine for what would be the new DC in our new world, right? In new DC world, which is the Hill et al., right? Then that portion of the land would be still for that purpose. So Maryland would not have a claim to that portion of the land. But what about like the 95% other parts of DC, right? Because the Hill and the President's and the White House and whatever other parts of land are a relatively small part of DC, which is already relatively small. So how about the other 95% of land? Well, the other 95% of land wants to become a new state, which isn't DC now, is it? No, now it's apparently going to be called Jefferson. What they want to call it, I forget exactly. Jefferson State or whatever, doesn't matter. They want to create an entirely new state out of this land, which was given by Maryland for the purpose of creating DC. Well, it's no longer now DC now, is it? Now it's the new state of Jefferson whatever, which isn't the purpose for which Maryland gave the land. So going back to like common law land 101, right? You give land to somebody for a purpose. It's no longer being used for that purpose. It reverts. So Maryland has a pretty outstanding claim for the 95% of DC that would no longer be DC and now wants to be a separate state. Now, presumably, only Maryland could raise this objection because only Maryland would have standing. So the question might become, would Maryland object? Well, on the one hand, it's 2 more Democratic votes, which, would please Maryland at the moment. But on the other hand, this 95% of DC, which is all the people who live in DC, remind you, that's kind of the point, right? That's kind of the point of what they're doing. So we are specifically carving out this new DC, right? Which is supposed to have no people in it, all right? So we are necessarily, all the people that live in DC, all of them, would now live in this hypothetical new state. Why might Maryland want these hypothetical people to live in the state of Maryland instead of the hypothetical new state? And the answer would be taxes. Taxes. The people that live in DC include some fairly affluent people, some fairly affluent neighborhoods with some fairly affluent money. And so Maryland might be very, very interested in saying, we're not so thrilled about this new state of Jefferson because, we'd like the tax revenue. And if there's a new state of Jefferson, the new state of Jefferson would be getting the tax revenue. And we'd like that tax revenue very much, please. So what might bust this all apart? Not so much the 23rd Amendment as money. Money might bust this all apart. So I think Maryland has a pretty good case, if it wants to raise the issue over this, that this is not legal. We gave you the land for the purpose of being in DC. You no longer want to be DC. That means it's our land now. Yoink. So that should be fun. And then I guess we have to figure out who gets to hear that case, which is even more fun because who's involved in this hypothetical new case? I don't even know. Then we also have to figure out who the parties are. This is fun. If Congress votes a new state of Jefferson, is that now a state for the purposes of original jurisdiction? So is it now the state of New Jefferson, which may or may not exist, versus Maryland? Or Maryland versus the state of New Jefferson, which may or may not exist? Is that an original jurisdiction case? I don't know. These are complicating questions. So we'll figure out if Maryland wants money. And yeah, so that could be fun. But that's a bigger wrinkle than the 23rd Amendment, is the land grant from Maryland. Maryland might want the land back because it comes with money. And Maryland will be like, yay, money. So there you go. So, yeah. Fun times. Matt asked on April the 27th, so in the Supreme Court Second Amendment brief from Mr. Paul, he stated, citing a case but not quoting, so it's his own words, that the need for self-defense beyond the home was even greater in early America. Doesn't this cut against his argument on the basis what's reasonable then may not be reasonable now? No, because it goes to the scope of the right. So if there was a right, because the need was there, the right still is there even if the need's not there, because that's how rights work. I mean, the Third Amendment is still a valid amendment, even though the need for it is not so much there today. You know, there's not a lot of need for the Third Amendment, but the Third Amendment is still a thing. You know, last I checked, Congress was not trying to put a soldier inside of my house in order to live there. So, you know, the need for the Third Amendment is not necessary, but it's still nevertheless a right. So I still get to say you can't put a army person inside my house without me saying okay. So I don't think it cuts against. Constitutional rights tempered with reasonableness and all that jazz. No. Seems like at least something you're going to say more. Am I missing something? No, not really. I just don't think it's relevant to his strain of argument. With how particular he was in the rest of it, seems out of character, especially after checking the citation itself. Seeming stronger they made for argument. I don't know. He's smarter than all of us. He's smarter than all of us, Matt. So let's not read too deeply into Paul Clement's ideas. Berner said today at 6:56 p.m. Follow up on question: if Congress just shrunk the District of Columbia down to everything owned by the federal government, would that not comply with the 23rd? There's still a federal district after all. Yeah, it probably would comply with the 23rd, Berner. Yes, it probably would comply with the 23rd Amendment, but not so much with the land grant from Maryland, as I pointed out earlier. Tina said, I maintain that DC's release should have reverted back to Maryland. Probably. And Berner says that would be a solution that works, yes. Okay, great. So that's all the questions that were asked in the Discord. Now we'll go to questions that you've asked today. Rarely Care said, what do you think of Hopper Road Unsolved Murders case in Pinkerton, Ohio? I've never heard of the Hopper Road's Unsolved Murder case, so I have no opinion of it. But I would like to try to start getting into true crime stories. Now, I don't know how to do that. I mean, technically, I don't know how. Or more to the point, I don't know what that would look like for me. So I don't know how to tell a true crime story. I'm interested in covering stories. I just don't know how to do it. And I don't have a good conception in my mind of how to do it. So, because I could try to tell them the same way I'm telling the stories I'm doing now, but somehow that doesn't seem appropriate. So maybe at some point, someone will help me write a treat. What I really need is someone to write a treatment, right? I need someone to write a treatment, for a case, what would it look like for a story? And then we could try to do it and see if it works. So if you're interested in seeing some true crime stories and you have an idea of what that would look like for me, how I would present it, if you are interested, you can submit a proposed treatment. How would I actually tell the story? What would it look like? And submit it on my Discord, and maybe we'll get some ideas and that will help us. So just an idea if you're interested in that kind of thing. Tina Chihuahua says, chances of a Chauvin retrial. I think they're exceptionally low. I don't think the jurors' comments are going to be enough. I don't think him wearing the shirts is going to be enough. I don't think it's going to be enough for the Court of Appeals. I'm not super duper educated on the law here, so I could go into the law. The juror did mislead on his questionnaire at best, but then again, there was the voir dire process, so maybe it was something the team was supposed to be able to figure out in voir dire, and they didn't figure it out in voir dire, and so maybe it's their bad. It's not going to stick. So, I don't know that it's going to be sufficient. So yeah, I don't. Also, the idea that they went through the technical definitions of the thing, they actually argued them out on some of the technical details, might be enough to cure. So I think the odds of a retrial or a mistrial are very, very low. I still think that, in my opinion, the third-degree murder statute will not stand, because I do not think it is compatible with State v. Low. I reread the Noor decision, and I reread the judge. I read the judge's decision from the trial. I read the trial judge's decision relating to this, and I think the trial judge misread Noor. And I think that the Noor decision wasn't particularly helpful to this. I think it's easy to misread Noor. I think it's easy to misread Noor. So maybe I'm misreading Noor, but I've read it a couple times, and presumably the judge has, so one of us is wrong here. But I've read the Noor decision a couple times, and I think that because the Noor decision had this wonderful turn of phrase where they actually cite Low, and then they turn around and they don't quite get to where they need to be. So let me see if I can find this exact language where they did this, because it was okay. Yeah, so there's this language here where they try to deal with this, and they kind of the Court of Appeals misses the ball. The Court of Appeals misses the ball, and I think as a result, the trial judge missed the ball. So this is reading decisions very, very carefully, I guess. Okay. All right, so here's what Noor said, okay? So let me just give you a background about what this decision was in Noor. Okay, so this involves another police officer, Officer Harity. Officer Harity was driving in his car. Okay, yeah, I remember this. We covered this. Okay. So in this case, Officer Harity was called to the scene of a potential disturbance. He came to the scene of the crime, or the potential scene of the crime. He drove his car through the alley, and this woman came up behind him, and he shot the woman, and he was convicted. So there was only one person in the alley, all right? As memory serves, there's only one person in the alley. So the officer comes to the scene of this 911 call. He drives through the alley. He doesn't see anyone. This woman comes up behind him. He acts precipitously, shoots her, convicted of third-degree murder, okay? She's the only person in the alley. Okay? So, here's what the Court of Appeals wrote in Noor, all right? They said, over 100 years ago, our Supreme Court stated third-degree murder is intended to cover cases where the reckless, mischievous, or wanton acts of the accused were committed without special regard to their effect on any particular person or persons, but were committed with a reckless disregard of whether they injured one person or another. This is citing State versus Low, which we've covered on my channel before as well. Seizing on this language without special regard to their effect on any particular person, Noor argues that a conviction under the Minnesota statute for third-degree murder cannot be sustained if the alleged conduct was directed at a particular person, right? So he says, the Supreme Court said, you can't do it if it's with special regard to effect on any particular person, okay? Noor contends that because the evidence shows that his death-causing act was directed at the person who appeared outside the squad car, he cannot be convicted of third-degree murder, okay? So Noor says, look, State versus Low says it has to be without special regard to their effect on a particular person. The evidence shows I was directing it at a particular person, therefore it can't be third-degree murder. That's a pretty good argument, right? All right, then Noor continues. The court in Noor continues. This is Court of Appeals, by the way. The Court of Appeals in Noor continues. Several cases inform our analysis of the particular person issue. The first is Low. which I've cited, in which a defendant challenged his indictment for third-degree murder. The indictment alleged that the victim, Clara Burr, was pregnant, sick from blood poisoning and other diseases, and about to give birth. The defendant took Burr to a hotel room under the promise that during her sickness, he would provide her necessary medical care. The defendant, however, neglected to provide the promised care, and Burr died. The Supreme Court concluded that a charge of third-degree murder was not appropriate, reasoning that the applicable third-degree murder statute was intended to cover cases where the reckless, mischievous, or wanton acts of the accused were committed without special regard to their effect on any particular person or persons, but were committed with a reckless disregard of whether they injure one person or another. We do not deem it necessary that more than one person who was or might have been put at jeopardy by such an act. Low establishes that third-degree murder may occur even if the death-causing act endangered one person. And that's the mistake. That's a mistake. That's not the issue. That's not the issue. They're right. Low establishes that third-degree murder may occur even if the death endangers only one person. But that's not the issue. The issue is whether it was with special regard to a particular person, not whether it endangers a particular person. So the Court of Appeals states the issue. So they do their IRAC. They state the issue. They state the rule. They fuck up the analysis. They state the wrong conclusion. It's not the conclusion to the question they were asking. So the Court of Appeals screwed it up. Now, strictly speaking, what they said was correct, right? Strictly speaking, what they said was correct. So I don't know if the Court of Appeals in Noor was just, so one of two things is true. Either they screwed it up or they're just trying to be really clever and hiding the ball. So you'll have to take a guess as to which it is. Did they screw up or were they trying to hide the ball? So the district court, the trial court in the Chauvin case read this and is like, well, only one person needs to be targeted. That's what Noor said. It's like, well, that's not what Noor said. The trial court misread Noor. And they misread Noor because the way the Court of Appeals wrote it. So, yeah, I think that Noor does not speak to the issue, right? So the trial judge initially dismissed the third-degree murder statute because he thought it had to be endangering more than one person, right? And Lowe said that. So Lowe itself said he was wrong. He was wrong. He could have been overturned just on Lowe. He was already wrong. So then the court in Noor, in a completely unrelated decision, different case, says, yeah, only one person needs to be threatened, which is consistent with what Lowe had said. Then the trial judge says, well, I'm not going to apply Noor because Noor isn't valid precedent. He had his reasons. And they were pretty good reasons, actually. He had pretty good reasons for why he thought that Noor was not yet precedent. So there was an appeal already on State versus Chauvin, already happened, and returned back and said, yeah, Noor's binding authority the date it's decided. And so he looks at this and like, well, the only reason I wasn't going to do it is because Noor wasn't valid. Noor is valid, therefore I'm going to do it. And the defense tried to point out, they weren't speaking to this issue. You could change your mind. And the trial judge, for whatever reason, who has way more experience than me, and the prosecutor, who has way more experience than me, they looked at this and they're like, yep, we can do this. And I'm like, nope, no, you can't. So it's me versus the trial judge. How long has this judge been on the bench again? Because he's been on there a while. Hold on. And he had a career before that, too. Now, Peter Cahill, right? Yeah, Peter Cahill. All right, so how long has Peter Cahill been a judge here? Just before I, point out, okay, he's a 14-year veteran of the bench. All right, this is going really, really well for me. Peter Cahill is a 14-year veteran judge. He has previously worked as a public defender, a private defense lawyer, and a prosecutor. So, yeah, it's uncivil law. It's uncivil law versus a judge with 14 years experience in Minnesota with prosecution and defense experience, and I'm saying the judge screwed it up. So that's how well it's going over here in Uncivil Law land. But I've read it. I've read it many times, and I still think I'm right. So I don't know if I'm arrogant as shit. Maybe I am arrogant as hell because, and also the prosecutor, and also not just the prosecutor, mind you, the attorney general who was directly involved in this case, in every single part of this case, the attorney general is intimately involved. So it's me versus a 14-year veteran of the bench, former prosecutor, former defense lawyer, and the attorney general of the state. That's how well it's going over here in Uncivil Law land. But I still think I'm right. I still think the Court of Appeals screwed up the analysis. I think that they screwed up the conclusion. They wrote it in a way that could be misread. I think the judge misread it. I don't think the third-degree murder statute can stand. So, I guess someday we'll find out if I'm right or not. So, that's fun. But, you have to be a little bit humble. You have to be a little bit humble when you're like, I know better than a 14-year veteran of the bench and the attorney general. I'm smarter than them. You can't help say that and not be like, yeah, maybe that's just a touch arrogant. Maybe you're not all that, and maybe you should be a bit more humble. And that's why I keep rereading it. I'm like, nope, that's not what it says. I'm pretty sure I'm right, so we'll find out. Okay. And if I wind up being right on this, I would like to offer this as part of my sizzle reel for why I'd make a good Court of Appeals judge. So, hire me. Sigurd Helkson Crypt Keeper said, do you think the Chauvin trial verdict will be overturned based on the info found about one juror? I think it's unlikely, but I don't know the law specifically enough to be able to give you a good enough answer. But based on my general knowledge, it seems unlikely, but there could be a lot of information that would come to light that would change that. I'll have a better opinion when I read the appellate briefs than I do now, because the appellate briefs will cite the relevant law, and then I'll be able to analyze it. But based on what I know right now, I think it's unlikely. Tatter says, if I get into an argument with someone, let's say they take issue with something I said, and they attack me with fists. If I pull out a crime, is that a crime? Escalation of violence. Well, yes, because if they attack you with fists without more, mere attacking a fist would be a non-lethal attack. So you wouldn't be able to respond with a lethal attack, and pulling out a gun compromises an assault unto itself. So yeah, without more, I think you're probably in the wrong on that one if I had to guess. Dryzar says, the boring continuous education sounds more boring topic, boring presenter than the continuous education. Ew. Also spent 12 hours of standing at PowerPoint slides. You got it. It's 12 hours of staring at PowerPoint slides, and I want to die inside. Uncivil Law, are you a cusp zodiac? I don't know what that means, so no. Yellow Jacket essay. Couldn't they do that, but just given the population of Virginia and Maryland? No, that's not how it works. You can't... No. First of all, Virginia is not relevant to this equation because Virginia got all of its land back long ago. So all the land is Maryland's that is in play. Virginia has no land in play at this point. That ended quite a long time ago. But no, there's no way to do what you're saying. No. I suppose they could come to some sort of tax sharing agreement. That would be interesting. But then DC wouldn't want to do it, or New Jefferson, or whatever they're calling themselves today. They wouldn't want to give up the tax base either, because they need the money just as much, if not more. Waxima says, what's the likelihood of the retrial based on the jury story? I think it's unlikely based on what I know today. That might change as I gain more information. A. Hedinger says, on the question of shrinking DC, why would they not have to revert the land back to Maryland? That's what I was talking about. Drazzer says, where no one lists except the POTUS and vice president with their families. Yeah, they don't count for the purposes of this exercise. Besides, for a lot of they can't actually formally live in, they can't domicile in DC because, well, for a lot of reasons, no one has ever, to the best of my knowledge, none of the presidents have ever domiciled in DC. They've always kept their house, their legal residence outside DC. So, I don't think so. They don't live in DC because you have to be domiciled there to vote there. So they don't count because they're not domiciled there. They never have been. And yeah, I don't think, no. Matt said, when it comes to third degree, the crowds are normally permissible as it's not illegal use of force, however, here it was. Yeah, but by the time the illegal use of force comes into play, the crowd is already there. So I don't think, I understand what you're saying, but I don't think it works. But, you could try. Couldn't the federal government eminent domain DC? No. Not and make it become like, no. Not the way the Constitution's written. Contrarian says, have you ever read Lysandra Spooner's Constitution of No Authority? It makes the case it was only binding on the signers. No, and that's dumb. No. No. I don't have to read it to know it's dumb. It sounds like some sovereign citizen bullshit to me. Chloe Malavet says, honestly, getting a true crime would up your female viewership. Yeah, that's part of the reason I want to do it. I just have to figure out technically how to do it. How do I present it? I don't know. Chauvin said, 152 said, thanks for the stream with Hogla. You're welcome. Ricardo Waspania said, does a person punching with a fist matter, for example, if a trained boxer or MMA fighter, couldn't their fist be considered a lethal weapon? Well, the dominant question would be, do you know that at the time they're punching you? Because you can only rely on what you know. If you know, then we're in a different analysis. So maybe, yeah, maybe. If you know the person punching you is trained, then maybe. Then you have a different argument. Possible. Colonel Crown says, any general advice for someone about to study law? Yes, as a matter of fact, I would. There are a lot of good bar prep classes that teach you the multi-state. And if it were me, I'd be studying for the multi-state before you ever started law school. The reason I say that is because a lot of basically your entire first year is the multi-state. Okay, they're going to teach you the multi-state. But if you do the multi-state prep now, going into law school, you'll have a nice edge up on all the material. So if you want to do something really productive with the next 3 months of your time, study for the multi-state exam. There's some good things out there that you can do for not too much money, and start doing the questions and look at the answers, and learn why the answers are correct. Look at the question. Here's what I do: I look at the question, give the best answer I thought, look at the answer it provided. It'll explain the answer. Read it, understand it, do that. Study for the multi-state. Do it now, and then when you go into 1 year, you'll have a nice leg up because you'll understand a lot more material, and hopefully it will help you on your exams in the end. So that would be my recommendation. You're also going to want to study for the multi-state later when you're sitting for the bar, but why not do it now? There's probably a lot of law students who are looking to get rid of their Barbary books. So if you don't want to pay very much, there's some online courses that are pretty good. And if you don't want to pay very much, why don't you just put out a Craigslist, say, I will buy your Barbary books for not much money, because they're probably looking to get rid of them. So that would be my recommendation. Andrew Jesse Reynes, if you were a judge, you'd wear your cowboy hat in the courtroom. Probably not, no. Matthew said, wouldn't the POTUS get 2 extra electoral votes if they did a shrink thing? No, because the POTUS has never been domiciled in D.C., and even if he was, the terms of the 23rd Amendment say that Congress gets to determine how the electoral votes of D.C. are to be allocated, so it doesn't do what you're trying to do. Matthew says, thoughts on Linwood saying Biden is dead and Trump is the acting president. That's just stupid, and I don't have the time to deal with it. Colonel Crown says, you think sovereign citizen bullshit? Yes. Is that the agent, the settler, the corporation, or the person that Kurt making the claim? No. Just no. All those, I guess. King of Casuals. Is Florida's law legal with Section 230? Good question. Is it legal with 230? Probably. But there's some First Amendment problems that come more to mind than 230. Is there anything in 230 that directly contradicts what Florida's trying to do? I think they can get it will be a problem, especially in light of the case law. So I'm not saying it's a rock solid guarantee by any stretch. I think Florida probably can win on the 230 issue, although I wouldn't guarantee it. The First Amendment is a much more interesting challenge. So we'll see. Matthew says Barbary has free 1L master sets of courses. See, there you go. Yeah. So yeah, why don't you just sign up for the free 1L from Barbary? Do that. There you go. It's free. Chauvin says, have you seen the lawsuit between the Logan Bros and H3H3? I saw Leonard French cover it, and I might get into it if things develop because, H3H3, man, why not? That'd be fun. So yeah, if I'll probably wait for the reply. I'll probably wait for the reply and then start covering it. But yeah. $25 from Ricardo Ospinilla says, could you do a gun control case like United States versus Crushank? I don't believe I've done United States versus Crushank, and I'm happy to do it because I believe I have done all my paid stories up to this point. Kavanaugh versus Bartlett, Sessions versus Diama. Yeah, I'm pretty sure I've done them all. So can I clear out all these? Probably not. Bot won't let me do this, will it? Okay, I'm just going to clone channel, and then I'm going to delete the channel. Clone channel, paid stories 2. No, clone channel, paid stories 2. Create channel, delete paid stories 1. Great. Rename paid stories 2 to paid stories. Great. And then I will make a notation to do your paid story, Ricardo, and I will be happy to do that. Where is his super chat? There it is. Ricardo Ospinilla. Could I do Crushank? I will be happy to do Crushank. Okay. Where were we? Great. Okay. Now, let us do some response. They are two big YouTubers. That's a good point. They're two big YouTubers. Yeah, that's a good point. All right. So I will start covering that then because, yeah, it will be good for the clicks. It'll be good for the clicks because I can tag them in the titles and stuff and get that wonderful, wonderful traffic. I'm all about that traffic life. So, yeah. Good point, Shav. Okay, I'm in. Dazara says, doesn't 47 USC 230 E3 preempt what Florida's trying to do? Well, let's take a look at E3 specifically because maybe it does. Let's see. What does it say? And lo. E3. Nothing in this section shall be construed to prevent any state from enforcing state laws consistent with it. No action may be brought, no liability imposed under any state law or local law that's inconsistent. Yeah, so a state can make laws that are consistent with it and can't make laws that are inconsistent with it. So you're still back to the question of, is Florida's law inconsistent with 230? So Section E3 doesn't tell you that answer. E3 just tells you if it's compatible, then great. And if not, then no. So you still are into, is it compatible with it or not? And let's see. Let's do a quick back of the envelope analysis. Liability for any action voluntarily? No. Any action taken to enable? No. Obligations, blah, blah, blah? No. Effective criminal law? No. IP law? No. State law? No. Communications? No. Sex trafficking? No. No. Okay, my back of the envelope analysis, I don't see any conflict with 230. There's still a First Amendment problem though, but I don't see any obvious conflict with 230. Now, that being the case, however, there's a lot of case law on 230, so there might be something there, but it's not obvious on this grounds immediately. Ricardo says, in my opinion, the Supreme Court is ignoring the 14th Amendment. Noted. Dazium says, what do you think would be the best step to increase the general level of legal education? I don't know. Trying to create liability and change the otherwise objection will not be seen to be consistent. No, I don't see that, because 2A protects any action that's voluntarily taken based on otherwise objectionable. But it doesn't say anything about involuntary actions. So I don't see the conflict. It's not obvious to me. Manny Gomez says, what are your favorite states to read about crazy law stories from? Oh man, they're all crazy. Just Florida gets the most attention. Yeah. All right. So let's respond to some comments. Oh, first of all, I have story time before we move on for the 139 viewer here. This is pretty interesting. All right. So because I was amazed. I was totally amazed by this. All right. So I was visiting my brother in Charleston, South Carolina. And I was at this bar in Charleston, South Carolina, waiting for a table to open up at a different restaurant for the evening, right? So I was there with my brother and his fiance, and I was drinking my drink, overlooking the waves and so forth and so on at the beach. Very nice. And this guy comes up to me, all right? This guy comes up to me. He taps me on the shoulder and says, I'm sorry if this sounds weird, but are you on YouTube? I'm like, yes. You're from Texas? I'm like, yes. I was like, oh, he introduces my name, which I forgot and apologized. I said, oh, okay. Hi, my name is Kurt. He's like, yeah, I watch your stuff. I'm like, really? He's like, yeah. So I said, okay, well, what year are you in school? He says, oh, I just graduated from law school. Just finished my 3L. I'm like, okay, well, so I gave him the advice that I usually give, which is, I think that the bar exam is a little bit more bark than bite. I think it's a little bit oversold in its difficulty. That isn't to say that you shouldn't study for it by any stretch, but I think there's a bit of a nocebo effect going on. So for those of you who know the placebo effect, if you believe in something, it's more likely to be true. There's the opposite of that, which is the nocebo effect. If you believe something will hurt you, it's more likely to hurt you. So I think there's a lot of nocebo effect going on. So I said to this guy, I would just recommend not stressing out about the bar exam too much. It's probably going to be fine. Just study for it. You'll be fine. Try not to let it do too much. And he says, can I take a picture? I said, sure. So we took a picture. I was like, if you send it to me, I'll post it. And, he didn't send it to me on Discord or anything, so I don't have it. And if I'd been a little bit sharper, I would have asked for a copy or taken a photo myself, but I didn't think about it at the time. So I don't know what to say, except that I'm at this random bar. In Charleston, South Carolina for the weekend. And a guy comes up to me and recognizes me from my YouTube channel. That's a thing that happened, man. So, whoever you are out there, by the way, if you tag me or in some way, if you could send me the photo, you could put it on my Discord and tag me that way, or tag me on Twitter or something. I'd like to get a copy of it and post it to prove that this actually happened. But yeah, this is a thing that happened. There were witnesses, including my brother and his fiance. So, there are witnesses to this event. But yeah, I was recognized by a random guy, a random 3L in Charleston, South Carolina. So that happened. So yeah, that was pretty interesting. That happened to me. I think this happened to me twice in Austin. I'm in Austin a lot though. So it happened to me once in an Alex Jones thing. Was it Alex Jones? No, it was Steven Crowder. Happened to me once in Steven Crowder thing. I think it happened to me one other time in Austin. But I'm in Austin all the time. And here I am just over here this weekend, this 3L, this newly graduated 3L, this 3L plus, I guess, says, yeah, are you that guy from YouTube? Are you from Texas? Like, yes, I am. Okay, well, there is that. Great. Yeah. All right, so let's respond to some questions or comments from from YouTube over the past period. Hope Eternal, in response to the 8-year-old dying of rampant neglect, said, if you're enjoying this type of content, you deserve to be put on a list. You know, when I say if you're enjoying this, please subscribe, I'm not necessarily saying that you agree or approve of the underlying conduct of the story. I'm just saying I hope you appreciate the legal content and legal commentary. And also, I hope you, to some degree, appreciate us bringing some light into some very dark places. So, you know, I don't think you have to approve of the underlying neglect of the 8-year-old. Hopefully, you don't have to do that in order to like the video. So, you know. What are you doing math here? 350 million divided by 25,000. Yeah, but that's U.S. numbers. I don't know. I could give you U.S. numbers off the top of my head. Or I could give it to you in my analytics. Hold on. What percentage of my viewers are in the U.S.? Hold on. So let's look it up real quick. Because you have to divide this by the total number of U.S. viewers here. So what are my U.S. viewers look like? Let's see. 73%. So it's 73% of 20. It's 73% of whatever my subscriber is count right now. 25,877. So that's 18,890. Okay, so then 18,890 divided by 350 million. That's 0. So that's 0. That's 0.00005. So that is tens, hundreds, thousands. That's 5/1000th of 1% of the population recognizes me or knows who I am. Then would recognize me, or even in worse math. It's not great odds. It's not great odds. It's not great. But you know, there you go. Does it break down by states? Yeah, but I don't know necessarily he was from South Carolina, although one could assume. But let's not get any worse. I don't know if it's 350 or 330. Does it really matter for the purposes of this exercise? No. It's one. Okay, let's round it up then. Let's round it up and be generous. It's 1/100th of 1%. Do we feel better now? Okay. Anyways. Psycho Boy says, good presentation and horrible story. It's a better track if you take into account how much lawyers drink. That's fair. That's fair. Fiery Red Podcast says, nice, thank you. Sledge and Wedge says, with all due respect, you just treated New York's rebuttal like New York treats New Yorkers. Mr. Kurt, I do believe you're better than that, but this being New York, we're talking about let it slide. That rebuttal was horrible. It was atrocious. It was absolutely a train wreck horror show of a rebuttal. I didn't do it because it's New York. I did it because it was bad. It was really, really bad. Really bad. Really bad. Canadian Casual says, unrelated question, how much does Florida's social media law work? Didn't federal government preempt this by passing Section 230? I just did a speed read of 230 and it's not immediately obvious it's preempted, although the First Amendment presents bigger problems. It's pretty telling that it's always right-wingers because that sue for the right to lie to people. I assure you it's not. Remember when Fox News sued for the right to lie while calling to news? They literally said it was their right to mislead. These people are doing the same thing. First of all, it's not clear that's a lie. Second of all, it's definitely not just the right wing. There's plenty of left stories around these lines too. If we want to go into media cases with left-wing sources, we could do that too, but you know. One hundredth of 1% is exactly 0.1. Yeah. Yes, it would be. Yes. That's what we rounded up. right? We rounded up 0.005, and then we rounded it up to 0.01. Yeah, that's what we did. So 1/100th of 1%. So, yeah. Paul DeFree says, I'm studying for the LSAT right now. Thanks God my reading comp is up there. Any advice for logical reasoning or logic games? First of all, I didn't know logic games was still on the LSAT. Is it still on the LSAT? I thought they took it off the LSAT. You might want to double check that. Or maybe that's in the future they're going to take it off. But you might want to double check on the logic games, because I thought they were taking it off or took it off or something. Otherwise, I've got no particular advice. There's logic games are just they're just matrix puzzles. So if you want to do more, if you want to do more logic games, just search for matrix puzzles. Matrix puzzle. This is called a matrix puzzle, right? Yeah, a matrix logic puzzle. Yeah, matrix logic puzzle. Logic puzzle. We did one of those on stream one time. It didn't go particularly great. Yeah, matrix logic puzzle. Or a matrix grid or a grid puzzle. So that yeah, just do more of those. That will help you give some more stuff up there. What's a tool or ability you wish existed to aid practicing law that doesn't? I don't know. The fix for this isn't making it a criminal to lie about someone. It's making it civil easier to accomplish. Maybe. You run into similar problems. Because, I mean, defamation law would already get you there. They were just trying to, like, criminalize it and make the government be able to preemptively act and stuff, so. While political speech is the most protected, the Supreme Court said many, many years ago, declared First Amendment does not protect the right to lie. They didn't say that. In fact, they kind of said the exact opposite of that. They said kind of the exact opposite in the stolen valor case. Let me see if I can find the exact citation, and I'm actually going to correct this post here if I find it. So, United States versus Alvarez. Let's see. I need the opinion so I can give you the correction. Let's see. Blah, blah, blah. Yeah, no, they kind of said the exact opposite of that. So I do have a citation here. All right, so I'm going to correct this guy on his citation. So, correct you. The Supreme Court actually said the opposite of that. Quote, even when considering some instances of defamation and fraud, moreover, the court has been careful to instruct that falsity alone may not suffice to bring speech outside the First Amendment. The statement must be a knowing or reckless falsehood. And then I'll give him the citation because I'm a good internet lawyer commentator, and corrected. See, this is one of the wonderful benefits of reading a lot of cases, because then when someone says something, you're like, no, I'm pretty sure they said the exact opposite, and then you can find it. It's nice. Nadro Polo says, is he hammered yet? Nadro, you're not helping. I want you to know that. In response to F. Cheer goes to the Supreme Court. Bum, I missed the live stream, but dang, it was fun. You three have made law fun? How dare you? How dare you? There's nothing like a dopamine rush when you get into winning in an argument. I know. Yeah, that's fun. This case is good for supporting standing for chilling effect claim. Yeah, there you go. Absolutely. I think it's important that we make it easier to identify false information. Now, I'm talking about the lawsuit in particular because I understand how they have a governing body. Well, there's nothing stopping from someone making an ad saying that someone said is false, which they do all the time. So if you want to say that things are false, you can do that, and people do quite to a long degree. Is there a difference between lying and a falsehood? Yes. Falsehood does not imply intent. Yeah, you need to have something more. You're thinking that I maybe yeah. So yeah, falsity alone may not be sufficient. The statement must be knowing or reckless falsehood, which is the same thing as a lie. Like, yeah, so yeah, that's on point enough for me. If you want to parse that, more, go nuts. Please start posting to Rumble or Odyssey. Thanks. Not at this time. I mean, I do carbon copy everything onto Utreon, just as a backup. But I was thinking there's just too many alternative platforms, and I don't really have the bandwidth mentally to deal with so many. So it's a question of, do I post to Rumble or Odyssey or Minds or Locals or insert other one. There's just too many to decide, and so I can't figure out what's the way to go here. So I just no. Dasm said, something I forgot to ask. Have you ever gone back to that line dancing thing you were excited for last year? I haven't, but then again, something happened since last year that dramatically affected line dancing. I was pretty excited about the line dancing, but my ability to follow through on that has been somewhat negatively impacted as of late. But hopefully someday. How many S's in slippery slope? That's cute. Selective enforcement, here we go. That's always a problem when it comes to any law. I probably need to do a more thorough thing on Tim Pool, because Tim Pool, every time he discusses law, makes me sad. It makes me sad. So he did a story from Fox News. I probably need to cover it separately, because Fox News said that the U.S. attorney in Portland dropped, 50 of 80 Portland-related courthouse rioting cases, blah, 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 including some that had confessions or something. And, I've long since come to distrust headlines when it comes to legal stories. So you're like, I don't know if any of that's true. I can go look into it and figure out what's going on here. So, and also, even if it is true, I could point out that, and then Tim Pool goes on to say some more things that are like kind of questionable. He's like, well, the police are just saying, well, they're equally enforcing the law. And then the prosecutors come and say, we're not going to prosecute that case. Yeah. And so police should stop obeying unlawful orders. I'm like, first of all, what exactly is the unlawful order here? Was unclear. It's like, well, they went after the Capitol rioters and they didn't go after the people, Antifa or BLM members involved in Portland. So the police should stop enforcing unlawful orders. I'm like, what exactly is the unlawful order here? Because, as you might have learned from every episode of Law and Order ever, there are people who arrest the offenders and the people who prosecute the offenders. And these are their stories, bum, bum, So the job of the police and the job of prosecutors are different. And the prosecutors can choose not to prosecute. It's prosecutorial discretion. It's not incredibly controversial. If you don't like what these particular prosecutors are doing, that's good reason to vote for other prosecutors. But, police shouldn't force unlawful orders. I'm like, what exactly is the unlawful order here precisely that the police are not supposed to obey? I was confused. And Tim seems to think prosecutorial discretion isn't a thing and hasn't been a thing since, the beginning of time or something. So when Tim Pool talks law, it makes me sad. But I will go into it and I'll try to figure out if anything Tim said has any validity to it at all. Because, try to figure out if it's just purely craven political, or if things fell apart, or blah, blah, blah. I don't know. You want some more FBIT? We do need to do another episode of FBIT because one of the people who got busted on Bumble now has a case. So we do need to do an FBIT. Maybe we'll do one after the stream today. I have some energy. I'm in a good mood. Maybe we'll do some FBIT. Blood sugar levels of 70 to 100 on the low side. People act like they're intoxicated. Noted. I believe it. I believe there's a lot of reasons people might act intoxicated. Yeah, blood level, stroke. I mean, there's probably any number of medical conditions that might cause someone to act drunk, including, perhaps most pertinently in this particular case, the guy hit the guardrail, which, I've never had the pleasure of hitting a guardrail in my car, but I would imagine symptoms that might be described as drunkenness might be a symptom that might occur if my car hit the guardrail. I'm guessing I might not necessarily be at my greatest equilibrium and most loquacious self and cognitively whole. So I didn't have to really look for a lot of reasons that this guy was acting drunk, because he hit the guardrail. I'm like, I'm sold. That's enough for me. Now, why he hit the guardrail might be another story that might require some further medical investigation. But I didn't have to think maybe drugs or maybe the beer instead of maybe guardrail. That could be a factor. Just thinking I'm thinking collision with guardrail might have some medical consequences. Red QWERTY said, stop straw manning. The main point is the prosecutor is left. So it drops the charges on the riders on the left and overcharges people on the right, even if they don't do anything. Okay, I wasn't straw manning, or at least I wasn't attempting to straw man his point. My overall point was that I don't think that Tim knows what he's talking about, because I don't think that the headline is necessarily accurate or tells the whole story, because I've had enough stories where I've definitely determined that to be true. The way the news reports law and the actual reality is distinct enough times for me to question it. So Tim is relating a story told by Fox that I'm not really confident in the first place. So my point wasn't I'm strawmanning him as much as, well, first of all, I am stating what his argument was as best as I can state it. And maybe I'm not stating it properly. You can go watch Tim's video for yourself, and you can determine whether or not I'm faithfully reciting his argument. But his argument was, these charges are being dropped in the majority of cases, because I think he said 50 or something out of 80, which would be a majority, even though there's confessions of assault, including, I think he said something like choking a police officer or something like that, which sounds pretty bad, right? If there's someone confessing to choking or clotheslining or something like that, an officer, and that charge didn't go through, that sounds questionable. Now, there might be fully legitimate legal reasons it isn't going through. I can think of any number of reasons it wouldn't go through. Any kind of violations from the police that might be problematic, right? So I'm not sure I necessarily trust that it's being done for political reasons. But even if it's being done for political reasons, which, was Tim's central thesis, Tim didn't seem to appreciate that prosecutors of left and right have been using prosecutorial discretion for political reasons forever. And that's kind of how the system is set up, for better or worse. He seems to think this is a unique problem in Portland, or is treating it like a unique problem in Portland, when it's not a unique Portland problem by any stretch. And then he said that the police should not obey unlawful orders. And I wasn't clear what those are. Because the police enforce the law as it's written. And okay. And they bring the case to the prosecutor. And the prosecutor decides whether or not to go forth it for any number of reasons. Political reasons might be some of them. Resources might be some of them. Justice, mercy might be reasons. But his idea of the police should defy, it wasn't clear. So my criticisms, I wasn't attempting to strawman Tim. I was saying he doesn't seem to understand that this is how it's set up, that this happens the other way around in right-leaning communities, as you'd expect. And his call for police to stop obeying lawful orders doesn't make sense. So hopefully that states the argument better. So, yeah. Biased judge gets slammed on appeal. Why in the world are judges not punished for abuse of law like this? Because judges have absolute immunity. That would be why. He's guilty of obvious constitutional and oath of office violations. Why can't remove people like this? Well, I forget if he was that a state judge, as memory serves correctly. So I don't know how the state appoints judges or how they remove them, but you might be able to. But I don't know the process for that. Why must we struggle with willfully and obviously unethical people? Well, because once you're appointed, you have to be removed through ethical and legal means, whatever those are. So, if a person is unethical or problem, then you have to follow a certain rule set. Classic concussion. I got used to tired of repeating the same answer over and over. Concussion sounds plausible, yes. And then in response to I'm going back to a regular release schedule, someone said inject it into my veins. That's nice. Thank you. Okay. Alternate title for the Lisa Blatt teaches rebuttal. You can't win at oral argument, but you can lose. Isn't that the truth, man? You cannot win at oral argument at the Supreme Court, but you can lose. Oh, yes, you can lose. Oh, yes. So the government didn't like the results of the state trial. They reactivated them to prosecute him in military court. How many times did the government get to stab at prosecuting a person? Why didn't they take it to federal? Well, they couldn't take it to federal criminal court because there's no federal criminal law that applies in this situation, I don't think. None is obvious. I understand the guy was a sleazeball, but I'm worried about is the precedent of giving the government mobile tries until he gets the result. Oh, well, in terms of that, I can help you out. There was a case 2 or 3 years ago at this point, which says that the federal government and state governments are separate. Let's try it again. It says that the state government and federal government are separate sovereigns. So it's not double jeopardy because it's 2 different governments. It's analogous, although the analogy might not be perfect, if 2 different states were prosecuting you for the same crime. Well, how might that happen, you might ask? Well, because the crime was committed in 2 different states, or parts of the crime were committed in 2 different states. So both states would have jurisdiction over you because parts of the crime were committed in the state. Usually the way the law reads in most states is that as long as an element of the crime, and it's written a little bit differently, so don't quote me on this exactly, but as long as a substantive element of the crime was committed in the state, they have prosecution. Now they still have to prove everything, but they don't have to prove it occurred here, right? So it might be. So I'll give you an example. Let's talk about conspiracy. Okay, yeah, let's talk about conspiracy. We can dream up a conspiracy that makes sense, at least in this hypothetical. So let's say that you and I are conspiring in, I don't know, Texas to kill a person in Oklahoma. All right? And we reach an agreement in Texas to kill the person in Oklahoma. And I'm just going to tell you, because it's my hypothetical and I get to control reality, I'm going to tell you that we did not conduct a substantial step in the execution of that conspiracy until we're in Oklahoma. It's my hypothetical, my rules. So we reached the agreement in Texas, but we didn't complete a step towards that agreement until we're in Oklahoma. Okay? So therefore, with respect to conspiracy, you need both the agreement and the act, right? You need both. So neither state has both those things, but each state has one half of it. So usually that means either state could prosecute you. In fact, both states can prosecute you because they're separate states with their separate laws, and you broke both sets' laws. So you did bad things both places. So that's why the military, now, if it's the military and the federal government, I'm not sure how that works. That might be a double jeopardy problem. I'm not an expert on that because it's both federal, so I don't know if that's double jeopardy or not, probably, but don't quote me on that. But as to how can the state and how can the military get them, oh, that's easy. The military is decidedly not an entity of the state. That one's easy. That one for sure. Yeah. Yeah, go with the Sideshow Bob example. Yeah, so that was good. So yeah, that was a good one, right? So Sideshow Bob, as memory serves, took the Simpsons to the five corners where five states meet, which, doesn't exist in reality, but let's pretend it happened in the four corners, which does exist. So Sideshow Bob took them to the four corners, and he comes up with some plan where he's going to kill Bart, with one piece of it occurring in every state, so that none of the states have jurisdiction. And unfortunately for Sideshow Bob, all the states have jurisdiction. So not so much he can't be prosecuted anywhere as he can be prosecuted everywhere. So Sideshow Bob needs to consult a lawyer on that one. Plus the fact it's crossing state lines and involves a minor probably gets federal jurisdiction in there somewhere. It's got to be a Mann Act violation or something, because we got this interstate murder happening. So yeah, it's not so much that none of them can prosecute you as everyone can prosecute. Sideshow Bob did not think that one all the way through. Now, if he had picked the murder zone of Yellowstone Park, it would have been a much more interesting episode. But maybe the writers of The Simpsons didn't know about that one. Okay, so someone wants to correct me, which I know. Okay. May it please the court is not actually on the lectern, but it's on the attorney's tables. Okay, fair enough. Notice to counsel, when counsel's turn comes to argument, counsel should proceed to the lectern without being called. Counsel should not begin until recognized by name. Counsel should open the opening argument with the customary words, Mr. Chief Justice, and may it please the court. Okay, fair enough. It's not on the lectern, it's on the attorney's tables. Correction noted. Fair enough. Enjoying the crisis. The conspiracy makes it not hearsay. What if they conspired to go buy some milkshakes? Is it still hearsay? Yes, because, well, yeah, it's hearsay. It's not hearsay because it's a statement against penal interest, right? There's nothing inherent against my interest. Let's go buy milkshakes. So it would be hearsay because I'm in a lawful conspiracy, so it's not against my legal interest. So it's against my legal interest when I say let's go murder people, not let's go buy milkshakes. Those are not actually equivalent statements in the legal hypothetical world, so yeah. In response to Toddy without a crystal ball, Salt strikes another blow. Someone catching up on their Toddy news. Being unable to procure a proper screenshot of Uncivil, we shall presume his appearance and hereby submit an image of Yosemite Sam. Fun. Appreciated. Colonel Crown says, whoa, Kirk got corrected. That's his career over. Unsubscribe. Bar license revoked. You should feel ashamed of yourself. I don't feel ashamed of myself because I feel good being corrected. And if I make a mistake, it's nice because then I'll be less stupid. And it also, I think, is a pretty good show of character that when someone corrects me and I'm like, oh yeah, I made a mistake, that I can be like, yeah, I made a mistake. I was wrong. Hey, it happens. I know it does happen, but I try to have enough humility to be like, when I make a mistake, I make a mistake. And when he said that, I'm pretty sure he's right. Because the only thing that's actually on the lectern is please don't adjust the microphones. I know that's there. I know it's in brass. So I got that one for sure. But the other one, I was like, oh, I thought it was in the lectern, but no, it's on the table. So he corrected me. I'm like, you're right, I was wrong. I correct the record. We're now all less stupid because we all are more correct than we were when we started. Yay. We're a legal education show, so we attempt to be as correct as we know how to be. Even if that means defying, a judge with 14 years experience and the attorney general of the state and so forth and so on. So yeah. Unless it's Matt doing the correcting, because Matt gets no credit for anything because he's a troll. So even if he's right, he gets bashed over the head. Yeah, we accept the corrections and we still make fun of Matt because, because also Matt makes corrections where he's wildly wrong. Matt sometimes makes corrections where he's wildly wrong. Like, for example, when I was trying to find that case that I couldn't remember, I couldn't remember the name Lowe. I was like, oh, there's this decision from Minnesota. I can't quite remember what it is, but I know it's from the 1800s, it's 1860s, 1890s, something like that. It's something about a pregnant woman and a saloon or something, but I couldn't quite remember, exactly what over here. And Matt over here is like, is it this case? And Matt gives me a case from Maryland. Different state than Minnesota. Might want to double check on that next time. Yeah, that was good. And it was particularly frustrating because he gave it to me in the middle of a live stream. So he gave me this important information right in the middle of the live stream so that I could talk about right in the middle of the live stream. And I'm like, this is not the case. It's from Maryland. Thanks for interrupting my live stream with bad information. That's great, Matt. Way to go, Matt. Intro sounds like you said League of Legends content, almost like you recorded after a streamer by maybe. What does this mean for schools when it comes to speech that's cyberbullying? We, at least in Texas, see David's Law. Expect to hold students accountable for speech on social media, or we're held accountable for suicide, self-harm. Well, I think it might be possible, right? We just have to do a different analysis. So the question is, if they go the way that I hope they will in the BEL versus Mahoney case. So they'll say, okay, Tinker does not apply off campus. Yay. So you can do Tinker on campus, which allows you for disruption or substantial disruption. And that's only on campus. And by on campus, we mean in the custody of the school or under the supervision of the school. So school field trip, school bus, school van, school events, school sports practice, school anything, right? So if the school is the supervisor of the thing, then Tinker applies. If not, not Tinker. All right, so then if not Tinker, then what? So maybe David's Law will be fine because maybe David's Law will be constitutional, right? We have a substantial governmental interest, and maybe this is enough. Maybe it's enough, and maybe it even passes strict scrutiny, right? So it's just a different analysis. Maybe David's Law doesn't pass muster, but some version of it would. So I think it's possible to write some version of a law that would allow the school to have the ability to deal with bullying and cyberbullying that would pass constitutional muster. It's just you'd have to, think about it a little bit differently. So, but I think it'd be done. Can the MLB or NFL or NHL place limits on political speech by players? Sure, they're private institutions. Why not? The Second Amendment is so lost in 1776. The fact that there's a case with corrupt Supreme Court just shows the lawlessness and relentless persistence of commie Dems. Well, don't hold back at all on your opinion, man. Lord. Yeah, the Second Amendment being lost in 1776, first of all, not that it really matters, but it's only been applicable to the state since the 14th Amendment. So there's that. Second of all, saying that the Second Amendment is law doesn't exactly tell you what it is, any more than saying the First Amendment is the law tells you what it is. That's a little bit dumb, with all due possible respect. Or maybe not respect because I called you dumb, or I called the idea dumb. Something is dumb. All right. So yeah, the First Amendment has been the law just as long as the Second Amendment has been the law. So saying the First Amendment has been the law doesn't tell you what the answer in BL versus Mahoney is inherently. Because, it's not inherently. First of all, it doesn't tell you what the answer is in Tinker, for that matter. Tinker could have gone the other way, logically. Especially if you leaned heavily on like a loco parentis idea. So if you went with the idea that in schools the government isn't a government actor, but really is in the stead of the parents, which is an idea that has merit in common law. So Tinker could have gone the other way. You could have said, this is a government institution, but it's not really, because the government's acting in loco parentis. So that means the government has as much authority as the parents would, which is, all the authority. So that means that the school can do whatever the hell they want, and they can ban all the speech they want, and they can do whatever the hell they want because the parents can do whatever the hell they want. It's the same idea that parents have a fundamental right to parent their children and rear their children, which I know is becoming less popular these days because of transgender issues. But let's move past that and let's talk about common law. So a common law, especially, like, parents have a lot of leverage. So Tinker could have gone the other way. So saying the First Amendment is the First Amendment doesn't tell you the answer is Tinker inherently. Right? It's not inherently obvious. So yeah, what's the answer in Mahoney? I don't know. And from the First Amendment? Oh, well, why do we need to have Supreme Court cases? Why do we need to have Supreme Court cases? It's been the law of the land. And every year the Supreme Court hears like 3 cases from the First Amendment. So surely the answer is obvious. Thomas says, when the feds acting as parents still have to largely follow the Constitution. First of all, it's the state government, not federal government in this context, because schools are state level authority. And second of all, if you go deep in local parentis, no, that would be the end conclusion. Or more to the point, it's just they have to follow the Constitution. It's just that it has no applicability because they're not acting as the government; they're acting as the parent. That's what in loco parentis meant, right? So yeah, it's a government institution. They're just not acting as the government; they're acting as the parent, and the parent can do fuck all. So the school can do fuck all. So yeah. That would be the logical conclusion that would flow from that. It's a government institution, but they're not acting as the government. They're acting as the parent. So, sucks to be you. Would be a potential conclusion. Yes, and also Matthew points out quite correctly, it's not 1776 in any case, because the Bill of Rights wasn't adopted till 1788. So, yeah, that too. So, there's that. Or is it 1789? Was it 88 or 89? Matt, when were the Bill of Rights ratified? Was it 88 or 89? You can be useful. Was it 88 or 89 that the Bill of Rights was ratified? Double check before you give me the year, Nat. Thank you. Colonel Crown said, in response to Texas about to adopt Wild West pimp style, which didn't get as much love on my community tab as I was hoping for, because it was hilarious. Colonel Crown said, not yet a convicted felon, says a lot about what the government thinks of people. $1791? Okay, 1791. Thank you, Matt. Thank you, Matt. 1791. There you go. In response to Lisa Blatt teaches how to conduct oral argument. From my understanding, train crashes were for entertainment in the 1800s. Thank you for this train wreck of closing. Thank you, Uncivil, for the stream. It was a fun one. You should rope some other lawyer friends. I'm trying to, man. I'm trying to rope all the lawyer friends. It's great. December the 15th, 1791, sold. I'm sold. Great. Did you guys not see the Wild West Pimp style? It was great. I should load it up because a lot of you guys didn't watch it, and it was very sad for me. It was very sad for me. So Texas is proposing a bill to have constitutional carry. So you'd be able to carry without a permit. I know, super scary, right? So Texas is proposing this idea right now. And one of the people has opposition, as people do, and their opposition was interesting. So let's share their particular opposition, because a lot of you guys didn't see it. And I really feel like it needs to be shared. So hold on a second.
That 21-year-old pimp, that 21-year-old trafficker who is not yet a convicted felon, roll on into any place you want and buy a gun under this provision and walk around in whatever way you want. No training, no understanding, Wild West pimp style. That's what this bill does. And then that pimp can roll into whatever small businesses in your community with their stable of girls, and they can flaunt it. Wild West pimp style.
It's epic. It's just epic, and it needs to be shared in every possible way. It just needs to be shared in every way. It's epic and deserves to be enjoyed. Yeah. Hey, no, I'm going to fight any copyright claim. I'll fight any copyright claim because that's government production, man. Yeah. So, yeah. Time to move to Texas so I could be a Wild West pimp. I know. Who knew these were options, right? Stable of girls. You could roll into any. Apparently, if this law passes, you get to also be a pimp. So you get to roll into a convenience store with a stable of girls. Wild West pimp style. Is it okay? Yeah. In response to the Micaiah Bryant shooting, watching me have a stroke, on a serious note, once you grab a deadly weapon and attempt to stab someone, your age, gender, and race become irrelevant. Yeah, right. You know what I'm thinking? Yeah. Link to the hat. Link to the hat. Oh, the hat is custom made, man. Can't link to the hat, man. It's custom made. You have to contact Texas Hatters in Lockhart for your own. Smiley face. No hat for you. In response to Texas about to adopt Wild West pimp style, Friday the 13th says, she says that like any of it is a bad thing. That gets a heart from me. Big ass heart. She says it like it's bad. That's fun. Cops get off inflicting pain. They do anything they can to become violent. It's a little negative there, isn't it? Would there be a derivative right to concealed carry implicit in the Second Amendment? Not holding my breath. Well, I don't know if there's an implicit right to carry concealed, but there's an implicit right to carry in some variety. Probably the better constitutional analysis, and I'm not saying this necessarily because I think it's right, but the better historical analysis probably is concealed carry can be banned, but not open carry. They're the dominant sentiments was that, a real man carries his arms in the open and only the dastardly carries it concealed. That sentiment has somewhat changed in the modern era, where we kind of think the opposite of that thing, or at least society does. So it's probably correct that the government can ban concealed carry, but only if they allow open carry. So the Supreme Court's decision probably should read some version of, you have a right to bear arms. The government can limit the time, place, and means, but they can't restrict it completely. So as between open and concealed carry, dealer's choice. You have to allow at least one of them. Dealer's choice. So that's probably the right analysis. Now, I think it will be interesting. It'll be interesting to see, because it's still possible, if the Supreme Court takes Hawaii v. Young. Where is that in terms of the process right now? Let me just Google that real fast. Because v. Young, certiorari, if I can spell certiorari, which I can't. United States versus Young, blah, blah, blah. Yeah, this is the en banc, right? Yeah. Has it been submitted for a cert petition yet? Probably. Let's see. This came down on March the 24th. Yeah, probably. What's the limit on a cert? Is it 60 days? I forget. What's the time limit for a cert petition? Ooh, there's some sort of leak in Supreme Court. Ooh, what is this? Scottish blog says there's a leak at the Supreme Court. Dun dun dun. Supreme Court doesn't leak, so it's notable. Oh, it's talking about a century ago. Oh, that's lame. Lame. Okay, so yeah, the Supreme Court is pretty leak-proof. And so, there was a leak 100 years ago. Lame. That's lame. Let's see if there's a cert petition for Young yet. Not yet. Let's see. Young. Hawaii. I don't think so. I don't think it's been I don't think there's a petition for it yet. How long do you get to petition for the Supreme Court? I need the Supreme Court rules. Hold on. Let's see. The rules. Rules of the Supreme Court. Let's see. Mission, consideration, certiorari, petition, appeal, 18. What is the rule today? What is the rule for everyone today? Let's see. When an appeal is authorized by law, within the time provided by law, that is not helpful. 60 days. I thought so. I was actually right. I just had to double check. Yeah, 60 days. So it was March 23rd, so they still have another month-ish to appeal for their certiorari grant. So if Hawaii v. Young asks for certiorari, the Supreme Court could add it to the docket. They could consolidate it with the current case. That'd be nice. And yeah, then it would mean rushing the brief. Well, because no argument's been argued yet. So you can consolidate it and you could push it further on the calendar. So you could argue, and instead of arguing in October, you could argue it in like January, maybe. So yeah, let's see if the Supreme Court grants certiorari in Young, see if they consolidate it with the NYSRPA case. See when they hold it, maybe December, January. If they have it January, then you're looking for a decision about now, next year, give or take. So we'll see if that happens. That will be interesting if that happens. Yeah, 60 days. Rule 13 says 90 days after entry judgment. Are you sure? They changed the rule? No. I was looking at the 2019 rules. That's the current rules. I pulled it right from the Supreme Court website. Am I misreading it? Oh, notice of appeal in the no, maybe I'm misreading it. Oh, wait. Okay, I'm misreading it. Wrong rule. Hold on. No. In opposition. $90 days. Okay, 90 days. Okay, I misread it. I'm sorry. 90 days. I read the wrong rule. 90 days. Okay. So 90 days. So they still have 2 months to appeal. So they could file, then they'd have to grant it, consolidate it. If they consolidate it, then you're looking at a later argument, February. So you'll be looking at a decision May. Realistically, you're looking the last day of May. So yeah. So we'll see if they grant that. That'd be interesting. Okay. You can buy a Wild West pimp style t-shirt. Excellent. I might have to get that. They issued an order extending it because of COVID? No, it's just in the rules. I just misread the wrong rule. I read the wrong rule. Maybe there was another order because of COVID. I just read the wrong rule. Anyways, they still have some time in either case. I'd love if some Second Amendment, if someone would reference the distinction people living in varied circumstances, like city versus rural answers. That's not how, it doesn't matter. And from a legal perspective, right? The First Amendment doesn't change. Second Amendment doesn't change. So no. It's 150 days. Okay, well, fine. 150 days. Well, I think the attorneys would be probably well advised to push it forward. See, because, they'd be well advised to push it forward, see if they can get it consolidated. I would. So yeah, I would try to get it done sooner rather than later. Response to DUI, great story on Uncivil. In response to the Wild West pimp style, I'm oddly okay with this, says Maximum Bacon. Okay. Taxes shouldn't pay for some students to get more resources than others. No, I don't think that makes sense. Not everyone is necessarily equal, and we're trying to give everyone an education or a basic education. So yeah, some people might need a little bit more help. And so the idea of giving some people a little bit more resources to get there, it's like, we're trying to give everyone a basic education. So trying to get to someone to some minimum. So yeah, you might have to spend money a little bit unequally to accomplish that objective. And not everyone's needs is not the same. So no, that doesn't make sense. No. In response to the Lisa Blatt thing, I feel like we need the Billy Madison line about us all being dumber. That's true. No joke. Supreme Court is allowed to run their court as they see fit. True that, A. Hedinger. True that. Yeah, waiting to the last minute isn't going to like you more. Yeah, if I were the attorneys in this case, I'd be making every effort to get that petition to the Supreme Court sooner rather than later. Yeah, I'd be making every effort to get to it sooner rather than later. Make it a little bit easier for them to order the consolidation if they're going to go down that way. I doubt that you waiting longer. The only reason to wait longer is to make the brief better, but how much better can it possibly get, after like 90 days? I'd be looking to try to get done faster. I mean, it's a Supreme Court brief, so, there's that, but still. The issues. You should be writing that post haste. So like if I really thought about how long would it take me to write a Supreme Court brief? Yeah, it would take me a while. But then again, I'm not as practiced as some people. So, yeah, it would be, okay. In response to public schools and disabled students, this was an activist decision that did not support the law. I'm not sure I see it that way. Because the court disliked the outcome narrative, the lawmakers could not create a system to help children who are unable to learn in the common education system. So they created some procedures with the goal of creating an IEP and called it good enough with no outcome required. Well, the legislatures couldn't define the outcome. Now, perhaps I'm a little bit more willing to deal with this because it's a little bit more in my field of practice. Because there is an entire patent for this. It's called a product by process patent. You don't see them as much anymore, but they're still valid. They're still in the books, right? So you can get a patent like basically one of two ways. You can get a patent a couple different ways. All right, let me stop and do this again. You want to patent the process for the thing, and you also want to patent the result. You want to patent the resulting thing. All right, so what might that look like? All right, so let's say that you're inventing the wheel. All right, so here is the mechanism. Here is the process for making the wheel. Start off with this lumber, cut it to this size, do this, glue it this way, blah, blah, blah. Right, so here's the process for making the wheel. And then the actual wheel, right? So you patent the process and you patent the result, okay? So both are patentable, which means that if you copy either one, you're in violation because there's two different patents there, right? So if you follow the same process but somehow come up with a different result, first of all, you probably didn't follow the process. But if you could, you'd be in violation. And if you did the exact same result by a different process, you can't do that either. All right. But the law recognizes, and this is mostly written for chemistry, but it's not limited to that, what's called a product by process. We literally can't describe the result. We literally can't describe the result. But we can describe how to make it. We can't describe this thing, but we can describe the process we use to create it. So if you get this thing and this thing and this thing and you mix it in this way and this formulate it and you heat it to this blah and you cool it to this thing and you do this, and bang, you've got magic. And the magic cures cancer. That's great. We like the cure for cancer very much, but we can't actually describe the result. Don't ask why, we just can't. We are unable through the scientific method to describe this in any way that makes any sense. So, all right, well, the patent office has a solution for you. So what you get is we have something called product by process. So you can get a patent to the product even though you can't describe it. So if someone figures out some other process for making the magic that you didn't think of, because it wasn't the only way to make the magic, if someone else thinks of some other way to make the magic, it's still an infringement because you got the result. You get a patent to the result too, even though you couldn't describe it, because you could tell us how to make it. And that's really all we care about in the end, is how to make it, to be quite honest. So you get a patent for the product and you get a patent for the result. So yeah. So that being said, the legislature could do product by process too, right? We can't describe what a individual education plan looks like, but we can describe how to make one. We literally can't describe the result, which kind of makes sense in the case of an individualized plan. How could we? How could we describe the result? They're individualized. How could we possibly describe what the result is going to look like? They're individualized. What is the output plan going to look like? We have no damn clue. But we can tell you how to make it. We know how to do it. We just don't know how to describe what it is at the end. So, okay, so let's assume that's what going through the legislature's mind in the case of the individualized education plan. All right, so what do we want to do? We want to give every student a basic education. Well, what does that look like? Well, we can describe that pretty well. We have basic standards of education, basic standards of testing, blah, blah, blah. It's like we know what a basic standard of education looks like. Okay, great. So what does the process look like for the normal student? Well, for the normal student, we can describe that too. Like we know what the result looks like. We can describe the normal plan we can put together. Okay, what does the plan look like for the IEP student? We have no damn clue. Because we can't have a clue in advance, because that's the entire point. But we know what the output is supposed to look like, right? So it's product by process. In this case, the result is the IEP itself. So it's like an intermediate step, but still. It's like, follow this process and you get the magic. The magic in this case is the IEP. If you follow the project, if you follow the process, the magic will emerge. And the magic will get you to the end result of basic education. So, individualized student, magic, IEP, basic education. Great. So we describe the magic. Okay. So can the legislature do that? Sure. Why not? It's like, follow this process and the magic will emerge. This is what we do. We can't describe it. Of course we can't, because it's individualized, but we can describe how to do it. And if you do it, you'll come up with it and it'll be great. Okay, great. So the legislature here makes some process or procedure with the goal of creating an IEP, and they call it good enough with no outcome required. Yeah, probably because they couldn't describe the outcome. Literally, it's impossible. The outcome is the IEP. How could you possibly describe it? It's individualized. You can't. It's impossible. So follow the process and the magic will emerge. Yeah. The parents found the school plus treatment centers more effective than the public school. It wasn't just that it's more effective wasn't the problem. And the court decided to punish the school district for not following the procedure, even if the results were going to be the same. Well, yeah, that's right. You are required to follow the process. Yes, it's product by process. Yeah, even if the end result is the same, which you don't know that, incidentally, because you didn't follow the process. You're assuming that. Maybe it would have been the same. Maybe he would have been just as worse off or just as well off either way. But you don't know that because you didn't follow the process now, did you? And besides, you're required to follow the process. The process is important. The process is what you're supposed to do. So yeah, the Supreme Court says, the legislature says, go follow the process. You didn't follow the process. So, you didn't follow the law. Yeah. We are not present any facts to indicate the procedures were not followed, and the court comments only on the result they not being wanted. Well, it's the Supreme Court, so they're being a little bit different in their level of analysis. But the Supreme Court says it wasn't followed, and the Court of Appeals probably went into more detail, and so did the District Court beyond that. Because the Supreme Court doesn't have to explain that part of it, because that's a fact. That's a fact. The Supreme Court could explain it, right? Or they could reiterate it, but they don't have to. Because the Supreme Court's about doing law now. So the facts are true. So the process wasn't followed. I know that as a matter of fact, because the District Court said so. That's what District Courts are for. Right? And there was no clear error, so said the Court of Appeals, and the Supreme Court is sure as hell not going to overturn them on that. So yeah, that's a fact now. They didn't follow the process. The Supreme Court didn't go into depth about it, but they took it as a given because they can. Because the trial court found it. That's what trial courts are for. So yeah, they took it as a given because it's a given. The comments are chock full of anecdotes, trying to make a case of why everyone should pay for a few people's disabilities without exception. Well, we don't need the anecdotes. We don't need the anecdotes because we have the law. It's not just people say you should teach my child. The law says you should teach my child. So the anecdotes are interesting and all, but kind of irrelevant because they don't need to make the case for why we should. The law says we should. The law that the legislature passed. That thing. No one wants to make the case for everyone must pay for all medical issues. A lot of people want to make that case. What are you talking about? No one wants to make the case that everyone should pay for medical issues? What are you talking about? Are you insane? Are you insane? A lot of people want to make that case. A lot of people want to make the case that everyone should pay for people's medical issues. In fact, to some degree, we already have decided that as a society. Have you heard of Medicare or Medicaid? Which has not everybody, but still, it's a lot of people. So no one wants to make the case that everyone must pay for everyone's medical issues. Are you nuts? Of course they do. People make that case literally all the time. Laws have been adopted along those lines. People continue to ask for more. What are you talking about? Yes, they do. Why? No one wants to make the case for everyone must pay for all medical issues. But they also do not want to define where the line is. The government no longer has to be a responsibility to accommodate children's special needs with the resources of others. Well, the line is the process. Yes, they do. They do want to define the line. They absolutely do want to define, and they have defined the line. It's product by process. Is this confusing you, product by process? We literally can't describe the result. It's impossible. It's impossible. The result is the IEP. We can't describe it in advance because it's individualized. That's impossible. We can't do it. We can't do it. But we can tell you how to make one. If you follow this project, the magic will cause the IEP to emerge into existence. And that will be good. We can't define the line. What are you talking about? The legislature has done exactly that. There was a statute passed. It told us what to do. It gave us instructions. Instructions we were supposed to follow. Instructions the Supreme Court found, because the Court of Appeals found, because the trial court found, were not in fact followed. And because you didn't follow the process, there was no magic. And the IEP didn't work. Because you didn't follow the process, there was no magic. You messed up the trick, man. You messed up the trick. Try again. It's a classic failure of activist courts making a bigger mess for everyone out of bad law for Congress. Well, maybe it is bad law. Maybe it is bad law. I don't know. I mean, I don't really have a strong opinion on the issue. I mean, it seems superficially like a good thing, but maybe it's not. Maybe the law sucks. Maybe the law's broken. I mean, Congress wrote it, so there's a pretty good probability, right? So maybe the law sucks. Maybe the law alludes to a magic that really isn't that magical after all. Maybe we follow the magic and the magic kind of sucks most of the time. So yeah, maybe it's broken. You know what I say as a judge? Oh well, it's what the legislature wrote, go do that, or at least do something that's compatible with that, or lobby your congressman for better laws. I'm not being an activist judge because I read a law Congress passed and I say, this is the law Congress passed. Go do that. You can't tell me what an IEP looks like. You're right, I can't. Congress can't. No one can. We can't because it's impossible. We can't do it. It's impossible because it's individualized. But if you follow the process, magic. So, go do that. Am I being an activist judge? No. I'm literally reading the words on the page. Well, I don't know what to tell you, but the Congress, what they wrote was, what they wrote is, first do this, then do this, then do this, then do this, and bam, IEP. Did you do those things? No? Okay, well, you broke the law. It's a bad law. Well, you didn't have to follow the law. That's the other thing, too. You didn't have to follow the law. Because remember that the way Congress got this through the state, got this to the states was with money. They bribed them. Right? You didn't have to even obey this law. You chose to obey this law because you like money. You went, yay, money. Okay, well, let's talk about Basic Contract Law 101. Right? Basic Contract Law 101. Mutual consideration. Right? The Congress said, here's a thing we want you to do. Here is an obligation we wish to impose upon you. Or another way of saying that is, here is consideration we want from you. You don't have to do this thing. Right? You don't have to do this thing. We want you to obligate yourself to do the thing. You don't have to do the thing. We'd like you to obligate yourself to do the thing. We'd like you to offer this consideration. And the states say, we don't want to do the thing. Screw you. And so the Congress says, aha, how about mutuality of consideration? How about instead of you give us a thing, we also give you a thing? And that thing is money. And the states say, yay, money. Contract law 101, guys. Contract law 101. Meeting of the minds. There's been a mutuality of consideration. In exchange for your obligation to do the thing, we have given you our obligation of the money, and you have not done the thing. Breach of contract. Go do the thing. We don't wanna. Well, you're obligated now, so suck it up. Even if the parents here lost, as well as those who come behind them, it'll take $100,000 in legal fees, not including time lost, for those parents to achieve the same level of success with troubled or uncooperative school districts. So, like, parents should never sue ever? You seem to be arguing that because the legal fees are really, really high, they shouldn't have fought the case. It would have been kinder to strike the law completely, no, and send the issue back to Congress to pass a law with measurable goals. No. No. How about just follow the process Congress passed? Follow these steps and magic will occur. It doesn't strike me as inherently whatever. United States versus George? Okay, I'll look it up. So, yeah, I'm not really buying any of this, but okay. Let's put that in paid questions. Where's my paid questions thing? I have too many channels. I need to purge some channels again. I need to purge channels. Thank you, Matt, for getting that for me. Okay, thank you. I don't really care about the 150-day thing. That's fine. I believe you. It's fine. Well, I shouldn't believe you because you get things half wrong, but that's okay. I'll believe you this time. Yeah. Oh, yeah. In the case of a case being heard by the Supreme Court will grant counsel. Oh, yeah. They don't let pro se anymore. They don't even allow it anymore. Unless you're also an attorney before the Supreme Court. They changed the rules a couple years back, and thank God for that. I forget the last time that someone actually argued pro se at the Supreme Court. It's been a long time. I think the last time someone actually did it was like the 80s or something. But they actually did change the rules a couple back. You no longer can argue pro se at the Supreme Court if you're not admitted to the Supreme Court bar, and thank God for that. Thank God for that, because, the Supreme Court is the Supreme Court. It, has impact that's kind of important. So, as much as we'd love to hear your rando thoughts, how about no? We're going to appoint you an attorney. Also, it's going to be really good. And it will be really good because an attorney who gets that call, I tell you what, man, that's an honor. That's an honor. You get the call from the Chief Justice, how'd you like to be pro se on this one? Shit, man, you may work harder on that case than you've ever worked on any case ever in your life. You're going to have a very motivated attorney, so let me tell you, it's going to, no pro ses at the Supreme Court anymore. I can argue pro se because I'm a member of the Supreme Court. You can't, so suck it up. Yeah. I'll do the case. Yeah, $24.99 is fine. Yeah, $24.99 is fine. Yeah, it's on mobile. I understand. I'll do the case. I'll do it. I'll get to it. It's fine. I'll do it on Sunday. It's fine. The problem with accommodations is it becomes simply impossible to achieve. No child left behind proved what failure thinking all students can learn. Some can't. It's reality. Well, be that as it may, you accepted the deal. You said yay money. So you can't turn around and say, oh, wait, I can't actually do it. That's not how contract law works. You undertook the obligation, so Yeah. Scarling said in response to public schools and disabled students, you've been hitting them out of the ballpark with case reviews. Loving it. Well, thank you. That's a very, very nice comment, and I appreciate it. I really, really appreciate that. Thank you. In response to Secret Service versus Park Police, so much fail plus so much comedy equals tragedy. And the last 5 seconds are precious. Yeah, I was very happy that the editor left that in, where it's just like my brain was completely fried. Yeah, so yeah. South Dakota State Supreme Court case on recreational marijuana. I don't know enough to offer an intelligent comment. If it's South Dakota, that's state-specific law, and I don't know South Dakota state-specific law enough to intelligently comment that, so I don't know. But paid workers calling themselves slaves get citizenship. Are you drunk? That comment makes no sense at all. I have a kiddo with an IEP. Even when your team is amazing, it's still work. Thanks for sharing. You're welcome. Yeah, I imagine it's a lot of work for everyone. So, yeah. In response to public schools and disabled students, this type of things makes a strong case for a general voucher system as a practical solution. Not the worst idea. That's a good idea. Yeah, that's a pretty decent idea. I don't have any problem with vouchers or charter schools. That's always a good solution too. Yeah. Yeah, in response to I can argue anything. No, you can't. Not the Supreme Court. They literally won't accept your papers. They literally won't accept your papers. You can petition for certiorari pro se. You can petition for certiorari pro se. But if they grant it, man, they're not going to hear from you anymore after that. Matt, you should know the answer to this question without looking it up. What is the famous case with the person petitioning for writ of certiorari pro se and winning the argument? Not only did they get it, they actually won the case. Do you know it? You should. Come on, Matt. You know this one. What is the case with the guy petitioning the Supreme Court for certiorari pro se, and not only did he get the case heard, he won. You should know this one. Don't make me beat you over the skull with it. If you look this, the one where the guy got, so you have to have an attorney in a criminal case. Yeah, you got it. What's the name of the case, Matt? What's the name of the case? Don't look it up. Please tell me you know this. Gideon. There you go. You got it. Gideon versus Wainwright. Thank you, Matt. Our law student partially redeems himself today. Yeah. So that would be the famous one, where the guy who is a prisoner because he didn't have an attorney, right? He didn't have an attorney. He wrote on jail hell stationery his appeal to the U.S. Supreme Court. Gideon versus Wainwright. Great case. So the school's approach to teaching how to create team cohesion is to blackball anyone you find disruptive to the team. And some great leadership display. That's pretty funny. What is the name of the effing case? Now, tell me now, I'm cheating. Which one, Zens? Did you ask me about a case? Oh, yeah. Gideon. No. The reason I asked Matt is because he's a law student. Yeah, Matt's a law student. That's the reason I asked Matt. Because Matt's a law student. I'm like, you should know this, Matt. So that's the reason I asked him. So, should do the oral argument on Gideon? I should do the oral argument on Gideon. Make a note of it in paid stories. Just make a note of it. Would you do me a favor? And I probably will. You know, I probably should do... I don't know if I should do the case or if I should do the oral argument. I might go back and do the oral argument. I might do that for a Supreme Court React. Do Gideon versus Wainwright. Oral argument. That could be good. Yeah, I think I might do that. Maybe I'll do that on Friday. So yeah, we do have a schedule now, sort of, kind of, at least. So our current schedule for our channel, all right, so we now have content 7 days a week again. Hooray. So our current schedule is Mondays, Thursdays, Fridays, and Saturdays are our days for daily releases at 4 p.m. Central Time or 4 p.m. Eastern Time if I forget to do the time conversion like I did last time. But yeah, 4 p.m. Central is what we're gaming for. So today's a Tuesday, so live stream. Tomorrow's Wednesday, live stream. Now I have to decide one of two things. I either have to re-host this show, which I think is on Nate Brody's channel this week, so I might do that, or I re-upload it, but I wouldn't be able to re-upload, so I might try to just recast it simultaneously. So I might do a simulcast, I think, for that show. So that will be Wednesdays. Thursdays, Fridays. Thursdays is going to be a daily release story. Fridays will be a daily release story or live, or maybe both. So then I have to decide, like, if I do a live stream, can I do them on top of a daily release? Because if I do a daily release at, say, 4 p.m., and I do a live for stream at, like, 8, maybe that would work. So maybe I can do both, but I still have to debate with that, play with that. So Fridays will either be a daily release episode at 4 and or will be live at, like, 8. So yeah, we might do it on Friday at 8 for a live on Gideon versus Wainwright or something like that. Then Saturdays is a batch story, and Sundays is recording day, which takes all my life out of me anyway, so that's a big day. So yeah, that'll be what we're doing now. Excuse me. In response to the Lisa Blatt thing, that's something I like to call cocaine poetry. Yeah, maybe. Quickening can be felt as early as 12 weeks, so 12 weeks would be 3 months, so fair. In Islam, you can't abort after 120 days, which is 4 months. Yeah, so, yeah. Legal bites. I love this comment very much. As someone with literal family members who were sent to Siberian gulags, I was extremely confused by the comments on the Soviet Union. You and me both legal bites. That was a lot, man. That was a whole heck of a lot, yeah. Nice hat, thank you. The idea of extracurriculars as voluntary is a very old concept that doesn't apply when ECs are preferred by colleges. Students are now compelled to join. No, you don't maybe understand the word compelled, and no, you don't have to. It might be a good idea, but you don't have to. And also, you don't necessarily have to do the extracurriculars through school. There are other extracurriculars you can do that I think colleges would be just as happy with. So, no. When the law's on your side, pound the law. When the facts are on your side, pound the facts. When neither, pound the table. Gunslinger bad, ninja assassin good. In response to the Lisa Blatt thing, Alex Jones has more coherent freakouts that involve human children being grown in cows. Maybe. Well, that's been enough. This has been 2.5 hours of Uncivil Law Hangout. Provolone Leaf says, have you heard about Hampshire? And if not, how do you feel about sustainable underwater hamster habitats? I'm confused. Would be my first thought. So, yeah. So I don't know why you'd necessarily want to have underwater hamster habitats, but okay. I've been Uncivil Law. If you've enjoyed this stream, you should like it. If you're not subscribed already, why not? You should subscribe. And I can tell the vast majority of you are not members because you don't have the little cool icon by your name. So I know you're not members because your name isn't green and you don't have the cool icon by your name. Why aren't you supporting the channel financially? Please support the channel financially. Did you know it's only 99 cents a month? It's true. 99 cents. For 99 cents a month, you can become a member. Are you wondering how to become a member? Well, Streamlabs just gave you the link just now. Also, there's a join button probably on your screen somewhere. Or is giving you the link from time to time. So, Matthew, you are not a subscriber either. You're not giving me 99 cents either. I should unmod you, but you're too useful. You know? So, yeah. See, A. Henninger has it right. A. Henninger is a mod and has the icon. Matt doesn't have an icon because he's not a paid member. Matt doesn't want to give me 99 cents a month. Don't be like Matt. Don't be like Matt. You know, join the channel, help support it for 99 cents a month. It helps the channel grow. Also because I think it's a positive signal to YouTube. So it's not really about the money as much as it is probably providing a signal to YouTube, which is one of the reasons I made it as cheap as possible. I'm working under the premise that having a lot of people be members of the channel is a good thing for YouTube, and they look at a percentage as part of the calculation, right? So it's not just about the money. It's literally about me getting people as members for the sake of it, because I'm betting that the algorithm uses it as a positive signal. And 99 cents was literally as cheap as I could make it. There was no level below 99 cents. So that's why I did that. So yeah. Apple devices don't let you join. That's why the bot reminds you from time to time with a link. Yeah. That's why the bot reminds you from time to time with a link, because it only reminds you every like 20 minutes or something. I think YouTube takes 30%. But again, it's not about the money. It's about providing YouTube an incentive to promote the channel. So, all that good stuff. Anyways, I'm going to sign off for now. I've been Uncivil Law. Until later, my friends. Hope all's well. Cheers and goodbye.